sign book? You brought a sign?
I did.
Okay. I seem to have lost mine. Okay, thanks.
And is your agendas here?
I'm going to use the one that I started because I got some notes on there. Good evening. This is the Board of Appeal hearing for March 20th, 2018. 19, thank you. We have one more member who's told me he's parking. I want to just give him another minute if I could. Okay, Dino, I'm going to hand down, we have 4, if you'd sign these. And Emily, our member over here, is Dino. Emily on the end. So, the hearing is recorded by MATV, so if there's anyone else here in the audience that's going to record the hearing, that's fine. You just have to let us know at ahead of time. Seeing none, we'll proceed with some administrative matters. Kathy here, for the benefit especially of Emily, maybe and Catherine, has stepped things up, and a lot of paperwork now is electronic. So you get the opportunity to get the package in preparation before the evening's event, which kind of in the past is how it happened. So that's a great thing. One thing I would note that on sending it out as you did this time, I know there's a balance. You have to wait to make sure it's advertised and advertised properly, and then send out our notices. So we don't want to send out our information too early, but it's also nice if we could get it out before the day of the hearing or the day before, because other than John, the philanthropist, most of us work, and if we have the package ahead of time, I know folks can go by, like, over the weekend and whatnot. So that's another goal for us. We have minutes from our most recent meeting, which was in January. We did not have a February meeting. And everyone have a chance to look at the minutes? Okay. You have a copy? Here's a copy. I'm sorry, I know, I want mine. I'm sorry, I didn't get a chance to give you any corrections. So on page 1, the very last line, I don't think that we were, I don't think the applicant was appealing a variance. He was appealing the overturning from the building inspector. This was the very last line. This was on the convenience store. So I don't think it was Miller's variance. It was a denial of supporting him by not overturning his decision. And it also had come to us to determine the 2-year period as to whether the property had been vacant for 2 years. On page 2, about halfway down, Member King pointed out that the property closed, that was property, Member King pointed out that the property had been the property closure was not in the owner's control. The court had stepped in and there was divorce and whatnot. Okay, very last paragraph. Second last sentence, to alleviate, to elevate traffic. I think we wanted to alleviate traffic. Page 3, the fourth paragraph. O'Brien reiterated the petitioner has committed to taking steps. And then under John King, second by Catherine, I'm down about halfway, motion on variance 701-5. Where is it? Second by Catherine to, can't read my writing. Oh, the next sentence, litter control. Will police the general area to include walking around the footprint of the building 3 times per day. And the last page, this was the vacant lot on Marvin. First sentence, petitioner seeks to allow single-family dwelling to be built in Residence A. And then continuing, the property consists of 2 parcels to be combined. Oh, that's correct, okay. Third sentence, the structure will be zoning compliant, all dimensional controls under the current zoning will be met. And I don't have anything else. So on with tonight, why don't we do 125 Highland Ave first? I'm sorry? Oh, I'm sorry.
I so moved to adopt them as is.
Thank you. Thank you. All in favor? Yep. Thank you. Yeah, 125 Highland. What are we doing here, Highland? iPad. Thanks. So this is the petition, this is petition 19-005. That's a new filing system that we're using, folks, by Rodrigo Biolgi and Alfredo Biolgi for an administrative appeal under Section 800.4.1.3, Chapter 12 of the Revised Ordinances of 1991, as amended, of the City of Malden. Namely, applicant seeks to appeal a decision of the building commissioner related to subject property at the property known as and numbered 125 Highland Ave, Malden, Mass., which is also known by the assessor's ID of map 42, block 210, parcel 004.
Good evening, Mr. Chairman, members of the board. Patrick McDonald on behalf of the petitioners with offices at 477 Eastern Avenue. As indicated by the appeal form filed, this is the request by the owners of the record owners of the property at 125 Highland Avenue here in Malden, Mr. Rodrigo and Alfredo Biagioli. Well, actually, the petition that was filed sought to amend a previously granted variance with respect to this property. I believe Commissioner Miller, who probably crafted the actual notice that was published, is treating it as a technical appeal of a decision by him. But if I could begin by just giving the board some background here. Messrs. Biagioli purchased the property in 2009. That property had been a single-family residence at that location in 2001, and the then owner sought and obtained from this board a variance permitting its conversion into a two-family residential dwelling in that time. That was obtained on December 20th of 2001. The decision of the then board that allowed that conversion from a single to a two placed two conditions on the grant of the variance. One was and a copy of that variance was provided to the board with the appeal and the petition. The first condition imposed by the board at that time was the installation of a fire detection and system to the satisfaction of the fire department. And the second was the installation of a residential sprinkler system in that property within 2 years of the date of the grant of the variance. We're unfamiliar with what exactly transpired at that time because these petitioners didn't own the property and I wasn't involved in any way with it. But it appears, I shouldn't say it appears, the second condition was not ever fulfilled by the original owner of the property who obtained the variance or at any time subsequent thereto. The conversion of the property, of course, was accomplished. It is a two-family and recognized as such here in the city, or perhaps Commissioner Miller may disagree with that. I think that's the gist of the issue here, is whether or not that variance remains valid with respect to the property, given that one of the express conditions of the variance has not been met by anybody in the 19 years approximately that have transpired since the grant of the variance. Again, these individuals were purchasers of the property. They've owned it since January of 2009, just over 10 years at this point. They were unaware of the existence of this variance as well as the condition that's at issue at this point in time. It came to their attention by virtue of the fact that they are currently in the process of attempting to sell their property, and they're in fact under contract to sell their property. And as a consequence of that, the buyer's attorney and or the lender's attorney, I'm not sure which, but someone conducting due diligence associated with the purchase and sale of that property, having done a title search, has picked up the fact that this variance was granted, that it was appropriately recorded, but that apparently that condition was not met. And I won't speak for Commissioner Miller except to say that I think his position on this is that the variance itself is now in question. It's certainly in question from the perspective of the buyer's attorney and the closing attorney, again, because from a title perspective, there is a question as to whether or not it remains valid given that an express condition was not complied with at the time. My position on it is that it remains valid, and I suggest respectfully to the board the following. The variance was granted and it was appropriately recorded. It provided for a 2-year time frame for the installation of the sprinkler system that was a particular condition of the variance. However, Mass General Laws, Chapter 48, Section 7, places a time constraint on the ability of a municipality to enforce zoning matters, including specifically conditions of a variance or special permit. The time constraint that is imposed by that statute is 10 years from the date of the violation. In this scenario, again, the variance was granted in December of 2001. The 2-year time frame for installation of that sprinkler system and therefore compliance with that condition would have carried it forward to December of 2003. And therefore, the failure to comply with that condition was enforceable for, at most, a 10-year period from December of 2003, which would have expired in December of 2013. And of course, we're here in March of 2019. My position, respectfully, to both the board and the commissioner is that the failure to comply with that condition did not render the variance void. It rendered it voidable. There is a distinction. The variance was effective, it was recorded, and it was in place. And the very fact that there's a statute that limits the amount of time a city can enforce a zoning violation, specifically including a failure to comply with a condition of a variance or special permit to 10 years, suggests that you've got your permit or you've got your variance, and it is potentially voidable in that if you haven't complied with it, the municipality has up to 10 years from the date the noncompliance occurs to take action. The action it would take would be a court-filed enforcement action and a recording of that action at the Registry of Deeds. That was not done, and at this point in time cannot be done. So my position, respectfully, again to the board and the commissioner, is that while this variance was voidable for 10 years between 2003 and 2013, it was not void, and that now, given that it is no longer voidable by virtue of failure to comply with the condition, it remains valid of record with respect to the property. Now, the reason we seek the relief that we do from the board is it's all well and good for me or some attorney to stand up and say that, but I'm not the individual who will be certifying title on this upcoming real estate conveyance if it does happen, nor am I the insurance company who will be issuing a title insurance policy on the property. And as I said, anyone can stand up and take a legal position at any point in time, but the closing attorney and the bank and the title insurance company in this prospective transaction are not going to feel comfortable until they see something of record from this board that makes it clear that that condition is no longer an issue and no longer a question, or brings into question the validity of the variance that allowed this property to be converted to a two-family. I would further suggest to the board that to the extent that this was a condition that called for the installation of a sprinkler system in a two-family residential dwelling, that was somewhat extraordinary. My understanding, and I don't purport to be an expert on the fire code, Member Sullivan, I'm sure, is much more knowledgeable, but I don't believe that a two-family home, a residential structure in Malden, needed to have a sprinkler system then. I don't believe a two-family two-family residential structure in Malden now needs to have that, and that this condition was probably in the nature of overreach of the board at that time, quite frankly. I'd further suggest that these particular petitioners are somewhat blameless in that respect, and to the extent that there might be a question of hardship here, I can represent to the board that there absolutely is. Again, I'm not an expert on the installation of sprinkler systems, but I'm advised that if compelled to do so now, they'd be looking at as much as a $30,000 expense to do that. So we're respectfully asking for the board to, if in fact the posture of this before the board is the building commissioner's denial or refusal to recognize this as a valid two-family based on that recorded variance by virtue of the non-compliance with that condition, I would respectfully suggest that the board can override or overrule that determination by virtue, again, of the statutory support for that, which is that given that this cannot be enforced and could not have been enforced at any point after 10 years of the failure, that, again, the variance itself was voidable, but not void ab initio. It wasn't void by virtue of the failure to comply with the condition. It was potentially voidable provided an action to enforce it was undertaken by the municipality within the 10-year period provided by the statute. And at this point, the city can't make these individuals put a sprinkler system into this property or any subsequent owner by virtue of that condition because it is no longer enforceable as a matter of statute at this point.
Could you quote that section?
I've actually made copies of it, Mr. Chairman, and I can provide. This time I brought enough for I didn't realize you'd have quite as many members tonight as you seem to have.
Oh, they're knocking on the doors. They want to get in here.
I've also got a copy for the building commissioner as well. I've highlighted the relevant language in the statute in this copy, Chairman, which I'll give to you.
Thank you.
Unfortunately, when we made multiple copies, I
Okay.
But the language I referenced can be found on page 4 of the 5 pages involved. I can't see I apologize, I can't see the highlighting on my copy either at this point in time.
On page 4, it's the lower third. If page.
Yes, beginning about halfway or so down. No criminal or civil action intended to compel the removal, alteration. I would suggest that compelling the installation of a sprinkler system at this point would qualify as an alteration of the property. Removal, alteration, or relocation of a structure by reason of an alleged violation of this chapter or of an ordinance or bylaw adopted under this chapter, or the conditions of a variance or special permit. So I think this matter falls squarely within that clause, and this statute contemplates, by virtue of this language, situations where a condition of a variance or special permit may not be complied with, and therefore a municipality may seek to enforce it. But it goes on further to say that no such action can be maintained after 10 years from the date that the violation occurred. And I, again, respectfully suggest that given that this is no longer an enforceable violation, and further that the violation itself did not render the variance void but only voidable, that at this point in time, this board can overrule or override the building commissioner, so to speak, and grant relief in the form of a clear statement from the board that this condition in that variance is no longer operative, which is what these petitioners need for purposes of their pending transaction.
I think I'm going to ask Mr. Miller to come up.
Sure.
I'd be interested, Nelson, in your position on this, but before you start, are we going to have to start addressing how we make sure that conditions are addressed and taken care of? So these folks filed at the registry as they're supposed to, and then who's watching to see if they do what they're supposed to? Now, do you know if there's any COs that were ever submitted or issued on this property?
No.
Is that where it would have been caught, so to speak, when they came to you? I'm talking about the prior owners now. They came to you, they wanted to get everything legalized. They come to you to get the CO for a two-family.
Yeah.
At that point, you review what's existing record-wise. You'd be saying at that point, well, I got to see that those conditions were addressed.
Yeah.
I'm looking at this like other properties that we're dealing with. I mean,
Well, and
where's the
that's-
oversight?
That's essentially what we're talking about, is what happened, you know, that those conditions were placed on the variance back in 2002, and then it was never questioned until now, and that's
And
when it was
these folks-
discovered. So to reiterate some of what Attorney McDonald said, you know, there was a variance granted. You can see that. There were 2 conditions that were put on it. In my opinion, neither one of those conditions were met. Obviously, the sprinkler system's not there, and we have no record of a permit that was applied for, issued, finalized, or inspected for the alarm system. So those 2 conditions weren't met. When I did meet with Attorney McDonald about this back when the application was made, there was no record of this variance being recorded at the registry. I'm not sure if that's changed since then.
Yeah, I think I have a copy.
And we have a copy of it? Okay, so at the time, there was no record of it having been recorded, which would have been an additional reason for the variance to be
It was recorded.
void, because it was never recorded. So the variance granted 2 years to install a sprinkler system. Typically, not typically, but state law provides you 1 year to act upon a variance before it becomes void. The board did grant them 2 years. Either way, the sprinkler system never happened. So in my opinion, the variance then became void. It never happened. So trying to come into the office and have a condition of a variance that didn't exist changed didn't make sense to me. With regard to the 10-year thing, the 10-year grandfathering, of zoning, the section that Attorney McDonald gave you, obviously that's accurate, you can read it. However, that addresses structures, and we're not talking about structures, we're talking about uses. There is no grandfathering of illegal uses, and if you convert your house from a single to a two-family without permission, either by way of a variance, a special permit, or a building permit, then it's been converted illegally, and there is no grandfathering on that. The 10-year grandfathering that you have in front of you is for things like, I put my house on my lot, but I put it too close to the property line. No one figured it out. 10 years later, my neighbor complains and says, your house is too close to the property line, move it. You say, well, no, it's been 10 years, too late. So structures and uses are different things.
What about today, Residence A only allows single? When this variance was granted, Residence A did allow twos, ones and twos. That change
It
was...
very well could allow it, but without a permit, a variance, or a special permit, converting your home from one to two, you can't do that on your own. You can't just suddenly occupy your single family as a two-family and personally declare it a two-family. Only an occupancy permit, a variance, or a special permit can do that. The way you occupy a structure doesn't dictate what it is.
The variance that the prior board issued was December of '01, and the property owner went and filed it at the registry in January of '02. However, it doesn't show it that it was recorded until June of '02. I know back then the registry wasn't moving as quickly as they do today. I don't know if that's the reason for it. But
I'm sorry, I didn't see that form wasn't available to me when this application first came in, but it sounds like it was recorded more than a year after it was issued?
About 8 months.
Oh, I'm
7
sorry.
months, yeah. All right, anyone else have a question for Nelson? John?
I don't know if this might be legal, so I don't know if our crack attorney here could handle it, but I'm looking at the deed that was recorded when the individuals bought this
From Fannie Mae?
from Fannie Mae. I mean, and they bought it subject to existing covenants, easements, encroachments, conditions, restrictions, and agreements affecting the property. And that was in February of 2009. So I don't know if that starts a new clock on all of this 10-year thing, because now they've agreed to...
You're talking about the purchase by the current owners, correct?
Yes.
Which was 2009.
Right.
Yep. Okay.
And they agreed to the conditions which were in the decision when they bought back then. So I don't know if that resets a clock or not. I mean, that's legal. I'm not.
I'll just state again that there is no 10-year grandfathering of illegal uses.
Okay.
There's a grandfathering of structures, not uses. But you have the section of the state law in front of you.
Catherine?
Mr. Miller, could you just clarify if there was a record of a permit and a certificate of occupancy for both units within that building, that there wouldn't be an issue with this variance today because the certificate of occupancy would have satisfied the need to call that a two-family?
I would say that the occupancy was issued in error if the condition wasn't met to
Right.
create a two-family by putting in the sprinkler system. But I think that certainly would start to form an argument that it was a two-family in error.
But that's not the case. There's no record of a permit or
Right.
certificate of occupancy.
Right.
Thank you.
I think no more lights. Thank you, Mr. Miller. I'm going to open to the public unless any of the board members at this point have any questions for either the attorney or Mr. Miller. Seeing none, would there be anyone here we're going to open the public hearing portion. Anyone here to speak in favor of us granting this variance? Hearing and seeing none, we'll close that. And would there be anyone here to speak in opposition? Okay, again, no one. I want to make a few more comments. I want to take it to today. And I've studied the neighborhood, and within about 100 yards, there's one single-family house. It's predominantly two-family and three-family, as well as commercial uses. There's a gas station, real estate office, convenience store, and again, mostly multifamily, two and three. So as far as the neighborhood, the composition of it, I think clearly this property should be considered more than a single family. In addition to that, we struggle in the city with parking. A typical lot is only about 3,500 square feet. This property is on a corner, it has 7,200, which is huge. There's ample off-street parking. I've been by the property. They look like they've done a tremendous amount of work. It's in good condition. I am disappointed that no one was there today when one of the board members went by. And I know Mr. McDonald seemed to only talk about one of those two conditions from the prior hearing. And I think he was mostly talking about and referring to the sprinkler system. But there was another condition in there about the hardwired smoke. So again, not having gone in the property, no one was there today. We don't know what's in there. So I'm a little disappointed in that. But again, looking at the overall neighborhood, I think the property really should be considered something more than a single-family home. That's my thoughts. Any other board members? John?
I think, that the board, if we look back at the board's decision back in, was it 2001? And 2002. But they thought too that it should be a two-family house, but they got conditions that they placed on it, and one of them being, the fire chief, who was able to inspect the property, for whatever reason decided, whether it's a layout of the house or whatever, that it was a condition that he wanted to see met. I can only guess.
I reread the minutes, and it came up by the fire member, Mr. Lafreniere, and he made it as a suggestion that he'd like to see it to the applicant, and the applicant responded he was concerned about the expense, the cost, but then there was nothing else in the discussion or in the minutes other than when it came to the approval, there was the condition on there to have that installed.
But it's not a general.
Yeah, I think
condition.
maybe Mr. Sullivan could address that as far as.
But I'm saying, because it's not a general condition, there must have been something that he saw that.
Specific to that property?
Specific to that property, that he felt that there was a necessity for it. And if we haven't seen it, it's difficult for us to make it in our fire professional here too.
So how many units are in there today? Okay, 2 kitchens, 1 unit on the first floor, and then another unit on the second and third? Second and third, 1 unit.
Can I go off that point? Maybe Bill can help us out with this. Was this a general requirement back then to have sprinklers? Is that what you're saying? Is that there was no requirement then to have sprinklers?
Then on now.
Is that right? Yeah.
Can you elaborate, Bill? So,
He's correct.
yeah, okay.
So so on that point, you're saying, and I think you're right about that, is that the fire person came in and said for whatever reason, I think that this should have a sprinkler system?
So you're implying that there may be something then unique and maybe exists still today that would warrant having that?
Yeah, because I think that's a critical part, and I think.
Then I think we should get in the building.
Certainly. And with respect to the inability to gain access, I want to express my sincere apologies to the board. That is on me. I neglected to tell my clients that you would be seeking to physically view the property at 10 o'clock this morning. So my sincere apologies to the board and to my clients. Please do not hold them responsible for a failure on my part. But I approached the podium just to point out that although I was not nearly as much a practitioner of this area of the law at that time as I currently am, I'm given to understand that former Chief Lafreniere, this was something personal to him. And if the board wants to see this property to feel more comfortable, especially Member Sullivan as the fire department member of the board, that this property does not represent something unique and therefore unusually needing either a fire suppression system or a sprinkler system of some kind, by all means, we'll do everything we can to accommodate that. But I do know from speaking to members of the community and practitioners that at that time and with that board with former Chief Lafreniere on it, this was something that Dennis Lafreniere felt very strongly about. He believed that sprinkler systems ought to be much more common than they are, notwithstanding the fact that they weren't technically required then or now by the fire code or the building code.
Everyone's filled out, but no one's blinking. Okay.
I was gonna say one more.
Excuse me, Mr. Chairman, may I make one more comment?
Sure.
Just for the board's edification, due to the fact that this all is been brought forth by virtue of an impending sale, the fire department representative was literally there yesterday for purposes of the conventional smoke and carbon monoxide detector inspection that is typically done by statute in a sale. And again, this property has changed hands on several occasions between the grant of the variance in 2001 and it was foreclosed upon by the original owner, the one who received the variance. The foreclosing entity, or Fannie Mae, then sold it to these individuals in 2009. A fire inspection would have taken place at that point in time. And as I said, as recently as yesterday, a fire department representative was there and issued a certificate of compliance, admittedly with respect to smoke and carbon monoxide detectors, because that's all that's required in a residential real estate transfer. But I only pointed out to inform the board that the fire department has had a number of occasions over the years since the grant of this variance to inspect the interior of this property, and in each instance has issued certificates of compliance with respect to smoke and carbon monoxide detectors.
And one was received yesterday?
Yes, a certificate of compliance was provided by the fire department literally yesterday for smoke and carbon
When is the
monoxide.
sale supposed to take place?
Well, that is up in the air. It's been suspended and postponed pending.
Due to this issue?
That's correct.
Anyone want to make a motion or have any more comments?
I think
You need the mic, John.
I have one more comment. Were you?
Go ahead.
Mr. Miller, could you just clarify that whatever decision's made tonight, they would still need to have a building inspection to make sure that the two-family was up to code, given the sprinklers are not part of a code requirement to make that a two-family, that there are fire separation issues that may need to be reviewed by a building inspector?
I don't think that would be required unless that was part of your decision, was that you would want a building inspector to inspect the property.
But I think we might feel comfortable that the fire aspect's been addressed by virtue of what took place today, yesterday, whenever it was. But she's calling for a CO, which you don't have, right?
Right.
Yeah. A certificate of occupancy.
Correct.
Where his department would go in with not an eye so much towards the fire, which we think we addressed yesterday, maybe.
Well, there's still fire separation issues that are beyond
Yeah, no,
smoke
there's other
detectors.
things that his department would look
Yeah.
at, yeah.
We would address all those items. Smoke detectors and sprinkler systems are things that are joint jurisdiction between us and the fire department. Just to answer some questions that have come up that I can answer intelligently. Single, 1- and 2-family homes have never been required to be sprinklered, ever, in Massachusetts. And the smoke alarm system that the house would have, if it were just your everyday run-of-the-mill 2-family, could just be local smoke alarms because of when the house was built. So the fact that it's passed multiple smoke detector inspections over the course of time isn't surprising. There's no way that a fire inspector could be aware of a variance that was granted in 2002 that required something other than what they have. So that's not really out of the ordinary. But if you were to, grant them their administrative variance tonight and declare it a two-family, then whatever conditions you put upon it would be up to you.
Okay. That answer it for you?
That answer it?
Yeah.
Thank you.
Mr. McDonald, I never just got clarification, though. You only were honing in on the sprinkler? I
Yeah.
took that to mean like the other condition had been met, because there were two separate conditions. But you just were
Actually,
thinking about the sprinkler,
I
right?
have focused on the sprinkler because that is what is creating the title issue for these petitioners. But I guess given that the issue has now come up, and not being sure that that particular condition was complied with, I would be making the same suggestion and argument to the board
Yeah,
that these are...
I don't even think for a two-family that a hardwired smoke system fire control panel is necessary. I don't believe so. Yeah. It's the same.
As it turns out, my clients informed me that they have hardwired smoke detectors.
Yeah, I
in the
kind of lumped the
property.
two together. Maybe
Right.
Mr. Sullivan could
Right.
clarify. Hardwired and fire control panel are two different things, I believe. Yeah. Okay. It said fire control panel in the decision as that second condition.
Just one last comment. If the board is inclined to grant the relief sought and condition it upon an inspection and issuance of a formal certificate of occupancy for a two-family, that certainly is not objectionable to the petitioners at this point in time.
Thank you. Okay, any other comments or questions? And if none, would anyone like to choose to make a motion?
Well, I'm still at a loss because I don't know what they saw back then that brought this up.
So,
Wanting us.
so given
sprinklers.
that the fire personnel were in there yesterday,
They don't look at that. I mean, that's not their job. I mean, if it's already a two-family, they're looking at that there's carbon monoxide in every floor, that there's, they look at other things too, that the locks are, they don't have double locks, and they look at, a series of things, but I mean, they don't know that this is a condition.
so would you want to make a motion that this board view the property?
Well, I don't know if I can make that motion. I mean, because now we would be getting into a time constraint. I mean, they would have to waive, because you wouldn't be able to do it, I mean, we couldn't come back unless you had a
Correct,
special meeting.
till the third Wednesday in April. That would be my sense. I was comfortable, I think, granting it because of the overall factors involved here. But I'm also comfortable if the board would be more comfortable getting into the property. I wish that had taken place today. So if no one else wants to make a motion, I shall. I'll make a motion that we table this and the applicants allow us to do a walkthrough. I'd be willing to go there this week on behalf of the board, and anyone else could accompany me, or we could all go on the date of the hearing a month from now. But the eventual hearing won't be until a month from now. And there's no guarantee that, you would be granted the variance at that point. But it sounds to me like that's maybe the sentiment of the board. So that's in the form of a motion.
I'll second that.
All those in favor?
Aye.
Aye. John? Okay. Catherine? All right, so by a vote of 5-0, we're asking that it's tabled till next month, and we'd like to get into the property. Again, maybe Mr. Sullivan and myself could go by one day. If you want to, I'll take a pause here and give you a card, and you folks could give me a call to schedule it. Okay?
Can I make a request as well?
Sure?
I think there are a lot of legal issues here that haven't been addressed in terms of our right to go back on this. If you could brief us on that a little bit, if there's any kind of authority for what you're asking for, that would be much appreciated, because I'm a little torn about a situation where there's a variance on record that was completely disregarded, and we're kind of being asked now to overlook that. And that's where I'm torn. So if there's any authority or anything you can help us out with, that would be much appreciated as well.
Is that something that you could address now?
Don't address it now, take some time. I mean, I'm legitimately torn about it. I just have some questions. So, maybe if we could just talk about that more next month, that's what I'd be.
So you're suggesting that we wouldn't even schedule the
No,
site visit?
No, I still do the site.
Oh,
visit.
okay, okay.
I'm just making a request.
All righty.
It's just some things I'd
All
like
right,
to know.
you're clear with what he's looking for, Mr. McDonald? Yes, Mr. Chairman. Okay. And as far as, why don't I talk with one of you to get a phone number? I'll talk with Mr. Sullivan, set up something. Okay, so we're going to take a recess here for a moment. That's the first one. How about 500 Broadway? Or as I like to know it, 474 Broadway. I need a minute. This is the petition, this is petition 19002, Exposed Signs and Graphics, Inc., on behalf of Taurus CD 195, Malden Property Mass LLC, for a variance of section 3.35.9.3.4.1, chapter 3 of the revised ordinances of 1991 as amended of the City of Malden, namely to add a second freestanding sign as per plans SGER 027386-2018 at the property known as and numbered 500 Broadway, known by the city as 474-488 Broadway, and also by the assessor's parcel ID, map 151, block 627, parcel 770.
Sorry. My name is Andrew Clark from Expose Signs, and I'm representing the Irving Court Associates. I was previously Cliffside Commons is now Strata Apartments. Thank you for hearing our petition. We were asking relief from the bylaw ordinance 3.35.9.3.4.1 for, we propose to have 2 entrance signs on the property. Currently, the property was originally conceived and built and permitted with 2 entry signs, and since subsequent bylaws have changed. But the entrance of this property with all the hardscape that's put in, all the stone walls, the fencing, the landscaping, and the median, it was all configured and designed around a 2-sign design. An individual sign is not legible if you put it on one side or the other when you're traveling along Broadway there. If you're coming up from the, I guess, the south, there's a parking lot in the adjacent property with cars parked there that would prevent a sign being seen from that, on that side. And if it's on the other side, it is traveling south along the same Broadway. You cannot see it because of the landscaping and the stone walls and stuff that are there. So there was always 2 signs there. They're asking to have 2 signs at that current, in their current locations. The cost to transform that whole frontage and that whole entryway would be quite exorbitant. Also, that is a really nice, it's one of the nicest entryways along that entire stretch of property there, that entire Broadway from, I'm failing the intersection, but all the way up to the Rotary at Route 1. So it's a nice, well-conceived and beautiful. It's also, it's required for safety for people to be able to see it when they're driving and approaching it, to give them enough time to make the turn into the property. And also, it would do no harm to the bylaw, since it was already, it has always been, since 2000, a 2-sign complex, so there's been there would be no change of use or change of existing conditions or anything that would cause detriment to the bylaw.
Okay, for the benefit of members, I'm looking at the second page of the handout, and it looks like they copied over something, so there's a couple corrections in the paragraph. You're not here on behalf of Irving Court Associates. You were a couple of months ago. That's a different people. At first, it's the wrong name of the who they're representing, and then in the last sentence, it's Route 99, not Route 30.
Oh, I'm sorry, that's right. They've changed it to Taurus.
So the section of the code that is applicable, that's at issue here is 3359314. Okay, 3359314. Freestanding signs for non-residential uses or building identification. 1 freestanding sign may be permitted. Did you say that there were 2 already existing?
There was always 2, yes.
Okay.
One on either side of the driveway,
Okay.
left and right. As you can see on the subsequent pages, they show the placement of the 2 signs.
Okay, and are you replacing the 2? I didn't go by, I'm sorry. Are you replacing the 2
Yes,
that?
the property changed,
Yeah.
ownership changed names. They've done millions of dollars of renovation
Right.
to make it
Been
up.
about 4
So they're-
owners in the last 7 years. So, are you putting in new signs right on where the existing ones were?
Exact same spot.
Same
exact
size?
Same size, same
Okay.
everything.
Are they illuminated?
They are
Were,
non-illuminated signs. There's ground lighting in the place there, but
same size, though?
Yep.
Okay. Anyone have a question? John?
Because I was going to ask about that, because not being that well read
Mike.
on signs,
Mike, John?
not that well read on signs, it does say it's LED halo lit push-through letters. What's that mean?
Oh, I'm sorry about that. No, I apologize, I apologize, this was my hearing. You are right, these are internally illuminated, but they're halo lit, so the letters, only the outline of the letters is illuminated.
So it's like the light's coming from behind it?
Yeah, so the light, so it's not like a face-lit sign like you might see on a storefront. The light is inside the cabinet, an opaque metal cabinet, and the letters are clear acrylic, and they push through the face of the letter, and the outline of the letter lights up. So it's a very upscale, classy look. It also has very minimal, ambient light coming out. It's not direct light flowing through the face of the sign. There's only the outline of the letters, and so at night you read the outline of the letters. It's a very kind of new and upscale look. Go with the new apartment.
And then you said they were going to be the same size, so you're not changing the size.
Not changing the size.
And this property, I do know it sits with curves on both sides, north and south of it, right? Cars, that's
Yeah.
a busy road, and you have cars coming around the curve from the north and
Yeah,
from
so-
the south. It's like a reverse S-curve kind of thing.
That's right. So when you come around, especially coming from the south, coming from north, you're coming around from that tight curve, and there's a parking lot in there. And so you really don't see, you can only see the opposite side of the driveway as you approach, if there's any kind of cars in that parking lot. And coming down the other way from Lowe's and from the north, as you're approaching it the same way, there's mature landscaping and wall right there. And as you come around that corner, you couldn't see it, and you would have to redo the whole median strip and everything like that to put it in a location that might be visible from both sides. So you sort of have to have one on either side for it to be visible as you approach the property from either direction.
And your lot basically follows that contour that.
Exactly.
On one end.
And I think, Member Sullivan was there today, and one of my associates was there, and he could see that there was, there is line of sight issues as you approach the property that cause hardship as well for the structural hardship of the property.
Did you meet anyone there today? Okay, great. Anyone else? No? Okay, we'll open for the public. Any public participation, either supporting the granting of this variance or opposition, denying it? Hearing, seeing none, we'll close that. And would anyone entertain a motion? Adam?
I vote to grant it, the basis being that I think there is something unique about this property, given the setup and given the traffic there, as the gentleman said.
Okay, and would there be a second? A second by John King, and all those in favor?
Aye.
Aye, and so it's granted by a vote of 5-0. Thank you. I'm going to do Mr. Maplewood Street, 100 Maplewood. This is yours. I don't know where mine went to. Can you check it? Remember where these are? You did? Okay. All right. Screw down. Bill, did anyone meet you at Papagino's? No, okay. Okay, so this is the 2019-004 petition by 100 Maplewood Street, LLC, for a variance of section 400.1.4.2, I'm sorry, .9. Again, that's 400.1.4.9. Offices, 400.1.4.13, and retail sales, 400.1.4.14, retail services. This is Chapter 12 of the revised ordinances of 1991 as amended of the City of Malden, namely dimensional controls, side yard setback, as per plans CMID 028536-2019 at the property known as in numbered 100 Maplewood Street, Malden, which is also known by the assessor's parcel ID of map 127, block 433, parcel 302. And again, I think it's Mr. McDonald.
Yes, good evening again, Mr. Chairman, members of the board. Patrick McDonald on behalf of the petitioner, 100 Maplewood LLC, Maplewood Street LLC. My offices are at 477 Eastern Ave. This is a request by this petitioner for a, what I would suggest respectfully is a modest variance with respect to dimensional control, specifically a side yard setback relative to the property at 100 Maple Street. I'm sure the board's familiar, that's the former McDonald's and more recently Papagino's site on the corner of Maplewood Street and Eastern Ave. The petitioner's proposal is to construct a new commercial building at that site, positioned at the northern edge of the lot, as you can see from the plan, from which 10 distinct commercial retail units will be created. This petition could be brought, or I'm sorry, this development could be done as a matter of right by this petitioner with respect to both the building and the uses. He only needs the relief of this board for, as I mentioned, the relatively modest side yard setback variance.
No rear? No rear setback?
No rear, Mr. Chairman. With respect to the statutory conditions, I'd respectfully suggest they're met. We do have a rather oddly shaped lot, an oddly positioned lot here. You can see the cutout renders it unusual. It's for a residential street, Maplewood, although Eastern Ave is a commercially developed, but Maplewood Street is a residential area, and this is an odd commercial lot in a residential area. With respect to hardship, the reason we're seeking the variance is that this building represents the optimal siting and optimal size from a commercial perspective. It provides 2,000 square foot rental spaces within the, I'm sorry, the units within the building are approximately 2,000 square foot rental?
1,000 square feet.
1,000, forgive me. This, according to Mr. Citos, who's very knowledgeable about commercial real estate, is somewhat of a magic number. It makes these units much more marketable and much more viable as independent commercial units. I further suggest to the board that again, given that this is a project and a development that could be accomplished by right, but for the 5-yard setback, that it is clearly not something that is more detrimental to the neighborhood or in any way can be considered derogatory of the intent and purpose of the zoning ordinance. This commercial development, as I said, is permitted, but this particular building, as the petitioner would prefer to build, and the siting of it is where the problem is created. The modest dimensional setback isn't likely to create significant issues with any abutters. As mentioned, the rear abutter is the abandoned railroad line, now the bike path, and on one side of the building is the street itself. There's no direct abutter impacted, and we're not aware of any objection, although it may yet be heard, relative to the easternmost abutter, but we don't believe that's a problem. So,
Would that be to the rear of the lot?
Forgive me?
That's to the rear of the lot.
No, that's a little house beyond, just beyond in the east, going towards Revere. That's what you're talking about? Yes?
No, but my question was to the left of that, behind the lot. If I'm standing on Maplewood Street looking at the parcel, right? Yeah, because the railroad is to the left if I'm on Maplewood Street, correct? Which is the bike trail?
Yes.
So I'm just curious, to the rear is another commercial property, isn't it? Wraps around the wood frame?
When I refer to the rear, Chairman, I'm
Behind the building you're
thinking as
talking
if
about.
I am standing on Eastern Ave and looking at the building from that perspective.
But given that it's known as Maplewood, I stand on Maplewood.
Right. You're correct. I'm sorry. So the northernmost boundary of the building and the lot abuts the rail line.
And that was why I had that earlier question about whether there was a rear setback issue behind, again, put me on Maplewood Street.
The ordinance is 400 2.5.1, you have a 0 setback when you have a rear.
Okay. Okay. Oh, again, you're talking about the railroad to the left.
Correct.
It's a corner lot, we actually have two front,
On Maplewood and Easton.
Maplewood and Easton, and the plan is to face the storefronts towards Easton and
Have all your parking out in front of it?
in front, request the city engineer to change the address to an Easton Ave address.
Oh, okay.
This is the optimal siting for both the proposed structure as well as the maximization of parking on the site and providing the best traffic flow on the site.
And I see there's, over 30 plus on the parking, so I'm assuming that meets every requirement. 42. And,
Yes.
oh, yeah, there's a couple more over there. And I see one story on the building, but somewhere I read about basement. So is it one story over basement? Thought somewhere it made reference to a basement in here. Okay.
Yep.
So it's one story over basement.
Correct.
Yeah, okay.
How much parking is required for this? So how many would that be?
40 parking spaces,
There'd be 40?
so we have 2 extras.
It's, as I said,
44 total, yeah.
the development is substantially zoning compliant and could be done of right, but for the relatively modest setback issue for which we're seeking the variance.
And given that Mr. Miller's office has referenced 3 different sections in the zoning, the .9, .13, .14. So offices, there's a couple contemplated different uses there, offices, retail sales, and retail services. So will you give us a flavor for what you think's going in there?
It could be
Without disclosing?
like a hair salon. We haven't rented anything yet.
Okay.
But that's why we choose.
You got a broad category there of, similar to around the corner?
Similar, yes.
Yeah, okay.
And they're all allowed by right in the district, the uses that we.
All those that are referenced,
That we referenced the
Yeah.
side yard setback for,
okay.
and they all have the same parking requirement of 4 per 1,000 square feet.
And the snow is met, is that right? I saw a reference to snow storage.
Yes, there are multiple snow storage locations reflected on
The
site
42
plan.
by 40 represents the area that you've designated as being snow storage, correct?
We have multiple areas, we have the front
Yep,
landscape area, almost 1,500 square feet, 150 between the driveways, another 166 on the right-hand side looking at the building, and about another 900 square feet adjacent to the driveway coming in off of Easton Ave.
and all those parking spaces that are fine as far as the dimensional,
Yeah, we
quite a
took
few
lot-
spaces there.
We took a lot of time laying the site out.
Right.
Everything complied. All the drive aisles complied, the driveways complied, space sizes complied. We
Still
actually-
gonna have 2 curb cuts on Maplewood and the one on Easton.
Yeah, we're proposing. That's what we're
And
proposing.
coming out today onto Easton, if I remember correctly, I'm usually halfway into my burger by then, but isn't there a sign that says no, right turn only? So you're gonna maintain that?
Yes.
Yeah, that's a tough intersection.
And we did increase the buffer between the rear of the residential house on Easton Ave and the parking area.
Oh, yeah, okay.
On the plan, you can see where the fence line is drawn. The fence is actually on the 100 Maplewood Street property by a couple of feet.
Okay,
Currently, the parking directly abuts that fence. We're at about, we added a 6-foot buffer there.
okay.
How does this compare to the Papa Gino's that's on there now? Is the building itself significantly bigger or in size?
The Papa Gino's right now is 2,000 square feet, the basement. That's more in the middle of the property, facing Maplewood. That Papa Gino's model doesn't work anymore. But that's why we're
Bill,
proposing
would you give that to Adam?
building individual retail. Oh, yeah, smaller. Easier to run.
Yeah, so Papa Gino's was 2016, and you've got, how many units?
10,000.
10 at about 1,020 per.
More sustainable, having smaller units.
Yeah. Bill, okay, 1 second.
I know you're referring to side yard setback, right? Just for clarification. So the side yard setback that we're looking at is actually the rear of the proposed building?
proposed building, looking at it from Eastern Ave,
Correct.
left and right side,
Left and right side.
yes.
Yes.
So right now, our
So
small-
that's, so the rear wall of the building meets the setback requirement?
Correct. The rear wall of the building is exempt from a setback because in accordance with 400.5.1, it abuts the MBTA right-of-way, which is now the bike path.
Correct.
We're allowed a 0 setback in the industrial district there.
Yeah, the only question I have about that, I was wondering, relative to abutters, I was by there today, and I know there's a large natural gas pipeline that flows underneath the bike path, and there's associated piping or valving, or relief valve, I'm not an expert on that.
Yeah, we'd be
So-
100% on our property, and we are proposing
They're considered a butter as well, correct?
yep, and we're 3 feet onto our parcel to leave a walkway behind the building.
Scott, just use the mics for the TV.
So we're 3 feet onto the property to leave a walkway and to leave a little bigger buffer between the railroad right-of-way and the building.
But you're saying this, our code says that it's 0, you can be right
Correct.
on the lot line?
But then we wouldn't have rear egress out of the building if needed. We wouldn't have a service area in the
Okay.
back to be able to bring, trash out or anything like that.
But I guess my question is that piping related to the gas line, has that company been contacted? Are there any concerns that they may have?
They'll be contacted
Relative to
before
when
any
the building's
construction. We're
being placed.
required to contact them before any construction.
My understanding, Mr. Sullivan, is that their biggest concern is to make sure that nothing is on top of that pipeline. They don't want any they don't even want you to put chairs or bike
course,
racks on
yeah,
top of that,
right.
so.
And I believe they have a requirement when you dig within a certain distance of the pipe, they need to be on site. So they'll most likely be on site when we dig the foundation excavation.
So I hope to retire this, but, so again, on setback, if I'm standing on Eastern Ave looking at your building, you certainly would normally need something in the back, but because of the section you're quoting, you don't. So the only setback from the Eastern Ave perspective that you're looking for is to the right,
Left and right.
left and right.
Left and right.
Okay.
The,
And it's 10 feet for each?
5 feet each.
5 feet?
well, the requirement is 10.
Right.
The frontage requirement's 10, the side
10,
yard requirement's 10. At the shortest distance on the left side, abutting Medford Street, we're providing a 5-foot setback.
Right, you show that on the plan, yep.
Yep. And then on the right-hand side, the shortest dimension is
5.7,
5.7 feet, and that's abutting
another commercial building.
the auto repair shop owned
The
by
Volvo guy, the Ranger guy.
Yeah, that's owned by J&J Realty, and we've spoken to the
Okay.
principal of that company regarding the project.
And I know Emily had a question about that setback with respect to the trail, but he's indicated it's a 0 setback requirement.
Yeah, my question was about, yes, how far back, but that's not the issue being raised here, so I misunderstood.
Okay.
So that's not a current issue of conversation.
Okay.
Mr.
Go ahead.
Mr. Chairman.
Oh, sorry. Go ahead, you're on, I think, John.
No, I just had some concerns, because I know that the city has talked to us when we've had some other properties that have come up for variances on the bikeway, and they're very concerned about, because it's a entrance to the city for a lot of people, they first see the city, there's a lot of people that use that, walking, riding. What are you doing in the back?
You suggesting some murals and,
We've spoken to Artline.
Okay,
I met with them 2 weeks ago
okay.
for another property on Eastern Ave.
We suggested this property to them. Mr. Larson, we met with at the property at 22 through 44 Eastern Ave, which is also owned by
Yep.
Mr. Cetos. They have a plan for the rear of that property. We mentioned this project. He did mention they have limited funding in this phase, but he was interested in hearing about it if it gets approved. And, we'll provide lighting at the rear of the building. The lighting won't, it'll be shining down, so it won't trespass across into the neighbors or cause a nuisance there, but it'll be enough that people coming down the bike path won't have to worry if someone, security hiding along there, and there'll be cameras on the building as well. So the cameras would most likely pick up a little bit of the bike path.
Okay. So, but that'd be something you'd be willing to do to make sure that the back of the building would be,
Definitely like, we'll have cameras on the parking lot as well as the back of the building. Just makes sense.
okay. Why don't we open it up to the public, if we could? And anyone that would like to support this variance being granted, if they'd like to come up and speak. Yeah, come on up, come on up. You have to let us know, we record it, so if you would, please. Just if you would, give us your name and address, and then speak right into the mic.
My name is Cindy Robelard, and I live on 9 Waite Street, which is right behind them, once you get past the bike path. My question is that the traffic on Maplewood Street is awful. So now we're going to have all these businesses there. Is that a concern that we should be, we should have? I mean, I can't get out of my street half the time because the traffic is so bad. But now we're going to have 10 more businesses. And I guess my question is, what time do these businesses end? Because, does it go on to like, can I ask you that question? Because you don't know who's coming in, right?
Probably not as late as Papagino's, but we can ask them
Yeah.
to address that.
Yeah. So like, would they be like 10, 11, 12 o'clock at night or something like that, or?
I can, the city ordinance addresses hours of operation for most businesses.
Oh, okay.
I don't remember what they are.
Yeah.
I'm sure Commissioner Nelson is
Yeah.
more familiar with them than I am.
So it's a reasonable time for people who go to bed early?
Anything beyond the hours specified in the city ordinance are required to go in front of the city council for an extended hours permit. That's a public hearing as well.
Okay, so that's not bad, so it can't be like, so our concern was, is it gonna be like, well, Papagino's, you can't compare, Papagino's never had business, so they were very quiet. So there was never business at Papagino's, so by 9 o'clock, there was no one ever there. So that was our concern, was the noise, the trash, we did have one place there that had trash, and rats came because they didn't take care of the trash. But so, McDonald's was there.
And we're not proposing any food. So any
yeah.
restaurants are only allowed in this district by special permit. So if a restaurant did want to come into this, if a restaurant did want to come into this location, they would be required to come back, not only for a special permit from the planning board, but back to this board for relief on parking as well. We don't have enough parking for a restaurant.
Okay, so then food wouldn't be an issue if it was left out or anything, so that's
So we're
good.
not proposing
Yeah.
any food. It'd be retail
Okay.
sales, retail service, and general office. And right now, it's similar to the project that Mr. Cito's developed at 471 Eastern Ave, which is the former Frederick Showit Hardware building next to the car wash. There's a hairdresser in there.
Oh, okay.
A personal
Oh.
trainer,
Oh.
McDonald's office is in there.
Oh, okay. So would it look like that?
We actually
Like-
have a rendering.
Oh.
It's probably gonna look closer to the Frescoes building
Oh, okay.
with,
Okay. Okay.
that'd be an ethos, a little bit of a design. All the storefront facing, the rear of the building facing you would pretty much be solid.
Yeah.
There would be service doors. These would be about 3 feet from the property line.
Yeah, that's not bad.
No. Now,
Yeah,
we live,
Yeah.
like my wife just
Yeah, I
said,
mean,
we
we're
live
right-
directly behind.
Yeah,
The
on
bike
the
path
bike path.
separates us.
Yeah.
Papagino's at one time had a fence separating them from the bike path. It was an old stockade fence, came down, they've never replaced it. Do you guys have any plans for putting in a fence there?
We hadn't,
Because you just have a little mound here, and then you're right on the bike path.
we hadn't shown a fence on the plan. There has been a lot of conversation back and forth about access from the bike path into the commercial properties. So we hadn't shown a fence.
I don't know if it's good to put a fence for security reasons, too. People can hide behind the fence, because it's gonna be lit up.
Yeah.
I mean, if it's a concern, we can put a fence up, but I don't know if,
Right now, it's a pain in the neck when people
know
are
if
coming over, but
Yeah,
anyway.
yeah,
it's something we can look at. Or we do what's best.
yeah.
And this, the building goes almost the length of the property, and that's where there's about
Yeah.
5 foot at the Maplewood Street side.
Okay, so it's
And
gonna be
about-
all along that path.
So the building is really acting as
Okay.
a fence or a.
Okay.
So if anyone is gonna access the property, it's gonna be at the very front of Maplewood Street or between Joe Salinas' property and ours at the very end.
Plus you get rid of the dumpster.
Oh, yes.
Dumpster's close to you.
Yes,
That
yeah.
won't be the case anymore.
Yeah, because this is what we'll see.
The dumpster's right
We'll
there.
see that.
Exactly.
Okay.
Okay,
Okay.
This is a good opportunity for me to tell everyone out there that they can go online now. I know in the past, it's difficult having us talk and you don't know what we're talking about. All this information is now available online, thanks to this young lady. You can go in and you can see his plans. You could have been sitting at home doing that. So I just want to tell everyone out there
I
that,
tried to get in your appeal thing.
Yeah.
The computer couldn't get in there.
right.
I have one other question though.
Okay, we're going to move on though, folks? Unless there was one more, did you want him to address? I'll let these folks finish. Let these folks finish.
I thought you were gonna put like 3 stores in there. I thought there was gonna be like 2 or 3 stores.
Name and address, please.
I'm sorry, my name's Bob Bishop. My mother lives right next door in the house, right next door.
On Easton Ave?
Yeah.
What's that, 900 something?
890.
890?
890, yeah.
Bob Bishop?
Yeah.
890 Easton Ave, the brown wood frame.
The lady came the other day and told us there's gonna be a few stores put in,
Which lady are we talking about?
some real estate lady.
Someone that works with Mr.
She
Tizos?
talked to my mother anyway.
Okay.
So we were kind of fine with that.
Okay,
But the traffic, the other day on Maplewood Street, it took me 6 lights to get to the corner.
and that's
6
before
lights.
he's even moved in.
Before any stores are there. Now, a couple little stores, like you said, 3 or 4, that wouldn't be that bad. Because Papagino's never had people. You put 14 stores in there, that corner, it's bad enough. There's so many accidents, accident after accidents there. Somebody should go down there and sit there for the day and see what I mean. You won't believe the traffic. It's unbelievable.
Okay,
It really is. And that's the only thing I was worried about. You know, a few stores, we have no problem with it.
Yeah.
14 stores on that corner,
well,
with that gas station there and
would you characterize them as stores, all stores?
well, they're storefronts.
Well, I want him to tell us what he's proposing there.
There's, instead of 14, there's 10 of them, and they're small. Some could be offices, like it could be like a law office, so you don't have that kind of traffic.
The traffic, there was no traffic with Papagino's, you know what I mean?
Right, no restaurants, no hair salons? Hair salons?
If you went down there, you would see what I mean.
Oh, I've been down there.
There's accidents all the time, and Papagino's never had anybody. That was like, forget Papagino's.
That's why they're out of business.
I don't know, it just seems to me that it's too many stores for that corner. That's all I'm saying. It's up to you guys, but
Okay,
I think there's, for the traffic, I don't think it can handle it. I really
all right.
don't. Okay?
Appreciate it, thank you.
Especially when the schools get out.
Yeah, when the school gets out, forget it. You can't go down that street.
Okay.
All going to school.
Thank you, Mr. Bishop. Were you folks all set? Did you have another question? No? Okay. All righty. I'm going to let you address those if you want in a minute, Andrew. So anyone else to speak? No? Okay. Why don't we close that, and if there was any, you wanted to just address any things that were raised by these neighbors,
I'll work with the neighbors, and if it's a fence issue.
but specifically on what issues are we talking about?
One issue that was brought up, if we need to put a
I
fence.
think I kept hearing stores, and I'm thinking retail and traffic. I think those are the big things I kind of heard there.
Right.
So it's 10 units, not 14? Or-
10 units.
Okay, so it's
10,000
10, not
square feet.
14.
Correct.
And-
He said 14.
It does allow for retail, though, correct?
Allows retail sales under 5,000 square feet, retail service, general office, and the current building is grandfathered for fast food,
Yeah,
and it's still valid. They haven't been out of there for 2 years.
okay. But you're not proposing any, I think I heard you say no food, no restaurants, right?
We're doing away with the fast food, which, just because Papagino's wasn't busy with some other fast food, you know, you could very well end up with another fast food place that is busy.
Starbucks,
More traffic, larger parking requirement, and
okay.
retail.
And not to minimize or marginalize anybody's concerns about what might happen there, I think it's important for the board to remember, as has been stated here, is, you know, these potential uses are allowed by right, and as I mentioned in my presentation, the development of this lot would be allowed by right, but for the slightly larger building footprint that's being proposed, and for which relief is being requested. Mr. Citos could build a building that was a mere 10 feet less wide, and he could put that there.
And you wouldn't be here this
And
evening.
that's correct. No relief of any kind would be needed.
Understand.
Thank you.
Okay. Nothing else, Sanders?
No, just economically, we're asking for this extra square footage because of the high cost of building the building.
Sure.
So
Okay.
if you can.
So if you get 10 units, if you're fully occupied, couple employees in there, their cars are parking. If there was a parking issue, because I know your other place has got some pretty good space over by the car wash, it's a little bit of a walk, but could some of the traffic, some of the parking go over? I mean, I can see the parking lot maybe being filled between employees and customers, and then more people are showing up, and now it's impacting these folks.
Some of the businesses kind of overlap. Some businesses are busier in the morning, some busier in the
Yeah.
afternoons, some are
But
busier.
all I'm throwing out in suggestion is if it came to a situation that it was getting problematic, you know, maybe some of the tenants could have some of the folks parked, because it's about 2 blocks down to your other place, right?
If there was an issue.
Yeah.
But we do satisfy the parking,
Yeah.
4 per 1,000.
Okay.
That's
I'm looking
something-
at 10 units there's got to be 2 people working, there's 20 spots right there taken up, so,
I mean, sometimes it could be just one.
yeah, no, I know.
It's small, only 1,000 square feet.
Okay.
And then you have the bathroom, closets. It gets eaten up.
Okay.
Space.
And the issue Mr. Sullivan raised about the gas, that's something that would get addressed before going forward?
Of course.
Then that's something, was that a revelation to you?
No, I
Okay.
brought that up, and
Okay.
so it's visible, so we have to address it.
Okay.
We'd be stupid if we didn't.
Okay. Anyone else? Questions, comments? No? Thank you.
Thank you.
And I think we did the public, correct? So I would ask if anyone would like to entertain a motion. Hearing none?
No, I'd move that we grant the variance based on, the fact that it's a very minimal change. They're actually going to a less intense use of the property. And to make it economically viable, the small increase is not going to be a detriment to the general zoning in the area coverage.
And the minimal setback issue is the only
Side yards.
relief that's needed,
got- they've
otherwise
got-
they could be by right.
Right.
So would there be a second? I'll second that. And all those in favor?
Aye.
Aye. Yeah, Bill? Okay, so I believe it passed by a vote of 4-1. Thank you. Oh, Adam was no yes. No yes. All right, this last one is a sign. 9 Whitman Street? No? Hello. Hello, one second. All right, this is petition 2019-003. It's Malden Auto Bodies / James Masson for a variance of section 3.35.9.1, chapter 3 of the revised ordinances of 1991, as amended of the city of Malden. Namely, the zoning ordinance does not support this type of sign located in zoning district A. And the petition is submitted the plans SGER 027581-2018, and they are for the property known as and numbered 9 Whitman Street, Malden, Mass., which is also known by the assessor's parcel ID, map 32, block 200, parcel 001. And are you Mr. Masson?
No,
Okay,
Stephen,
just identify yourself with name and address.
Stephen Caracciolo.
And address?
5 Waverly Street in Everett.
Bailey?
Waverly?
Waverly Street.
Waverly Street in Everett.
02149.
Yes.
Okay, so you are representing, who is the owner of the property? Because I have
Frank-
multiple names. I have,
Frank Boyland?
okay, he is still the owner. Okay,
Yes.
Mr. Boylan is the owner, okay. And then the applicant is, because then it says owner's name, Jane Masomi.
James Masomi.
That's the owner of the business?
Yes.
Okay. And the appellant is Malden Auto Body. Is that Mr. Masone's business?
Yes.
Okay.
Yes, it is.
And when I went by, I got the sense there might have been two businesses, a Malden Auto Body to the right and a Sergio to the left. Is that
Yes,
accurate?
Sergio's been there for quite a while. That's separate from us. So 2 different businesses.
But is it one property?
It's 9 and 11 Whitman Street. We're 9, Sergio would be 11.
But it's one property?
Yes.
Yes, okay.
Yep.
All right, go, you can proceed.
So we moved from Everett. We were at 87 Broadway in Everett, and the Wynn Casino purchased the property from Mr. Masoni, and we are leasing out 9 Whitman Street from Frank Boyland. So we didn't realize that you had to come in front of the sign commission to put up a sign. So the owner, we just took a sign from Everett, the shop in Everett, and put it on the front of the building at 9 Whitman Street. And we've sent in all the information that you guys required to allow us to keep the sign there. I think the biggest thing was that it was a residential neighborhood, but the sign's not illuminated or anything like that, and it's very secured to the building. And it doesn't overhang on the sidewalk or anything like that.
And James is the business owner of Malden Auto Body?
Yes.
Do you work for Malden Auto Body?
Yes.
Okay. And you folks moved over. When you moved over and took occupancy, was the Sergio in place to the left?
Yes.
Okay.
Yep.
So I just want to clarify one thing. In the application that was submitted by you folks, just to be clear, it said that you went before our sign committee and they interpret literally the code, and apparently it's not allowed for the reason you already implied. It's in a
Right.
residential area.
Yes.
And it said here that the sign committee told us to apply for an appeal due to the sign being larger than the ordinance allows. Well, there's no signs allowed. And then it said they have no problem allowing the sign, but we need to go before the board. I think they were telling you had the option and the right to go
Right,
before the board,
yes.
but I don't believe they were endorsing it, because,
No.
and I say that for another reason, because sometimes they do, and they'll send a letter down saying that.
Oh, okay.
And
Yes.
I didn't see one, so,
Yep.
okay. And the sign that you've already put up,
Yes.
it's the Malden Auto Body sign?
Yes.
Okay. Do you know if that is similar to, do you recall when you put it up, was the one that was taken down?
Yes.
Okay. And was it the same footprint, same size?
No, it was a wooden sign that was carved out with Mastercraft.
Okay.
American Mastercraft.
How about on size, though? Was it,
It was almost as long as the one that's there,
okay,
but it was very short as
the
height-wise.
depth, okay?
Yeah.
Yep. And again, you're only talking about Malden Auto Body, nothing to do about next door? Okay.
On that thing about the size, I'm just wondering, there's a picture in here,
Dated 2016.
16, yep. And the sign that's there is not quite as wide as the door opening.
But the height looks to be about the same, but not as wide.
I think that's probably 1, 2. I think it's 3 courses of brick high, and this is like 5 courses of brick high.
And there's no Sergio to the left.
And and the sign is substantially beyond each end of the door. So, I mean, this is a lot bigger. This is like, I bet square footage, we're close to twice square footage of the old sign.
Yeah, I'm still wrestling with, if it's, Sergio, if it's two units, yeah, I'm gonna, if you're all right, I'm gonna just ask our building inspector to weigh in on this one issue that's driving my thought process. If you get two tenants, are they each allowed, well, in that zone, and not even allowed, but, because there's clearly two signs.
Yeah, so
one for-
just to clarify
Please.
the issue that he's here for, the building had a sign on it for, I don't know how long, but certainly before our sign ordinance came into effect. So the sign on the building, even though it's a Residence A, is considered existing non-conforming, which means they could continue to have that sign forever. They could also, through our ordinance, replace that sign, but they couldn't make it any bigger. They could replace it in kind, the same size. So where the mistake that was made is, as he mentioned, was they replaced that sign with a bigger sign. So if they had a new sign made that was the same size as their old sign, they could have replaced it. They could have, they have the right to have a sign because they have an existing non-conforming sign.
And, and is this a second, they have a second sign? I mean, it's not worded, but I mean, there's a second sign.
Whatever signs they had, they're allowed to keep. It became existing non-conforming when our ordinance was put into place.
The Sergio looks almost new, though, also. Sergio
I
sign.
don't know when the Sergio sign was put in place.
I mean, we have a Google map from 2016 showing no Sergio to the left and the prior owner, Malden Collision, with, I think, somewhat smaller sign than maybe that's up than what's up there today. I'm going to let Mr. Sullivan weigh in. I think he might have a question or a comment.
So I was there today, Commissioner, and I saw the sign as it's pictured here, the large sign over the door. I also saw the sign that looks as though the front of the vehicle is crushed. Then there was a third sign that isn't pictured here, but it had the phone number and the name of the business. So there's a third sign on the building now. So there's a third sign where, in an area where no signs are allowed, but they could keep a sign the same dimension as the one that had been there previously.
Right.
Okay.
Right. The signs that were there prior to the adoption of the sign ordinance got grandfathered.
Okay.
And anything they may have added since then, absolutely, you're right, they can't have.
So I have photos from today.
They are allowed to have building identification signs without any kind of approval or review, obviously.
So I don't know when for example, the sign depicting the car that has been involved in an accident was added, or the sign that I saw today below that one, with what I believe to be the company phone number.
Our mailman had asked us to put the address on a sign.
That's another one, though, on top of what he's talking about, I think.
Yeah,
There's
no,
multiple.
the sign, I don't think the mailman needed the phone number. This is a very large sign right next to the old, rather
it has,
large sign.
Yeah.
Yeah.
We just pass these down to the other.
Commissioner, about the non-conforming use, that's the same, it's still non-conforming even though it's a new business putting up a sign?
Yes. Yeah, the sign on the building, unless the building was not used for 2 years, then it would lose all of its non-conforming status.
During the course of your involvement, did you happen to notice if you had permits for any of those signs that were put in?
No, I didn't check.
Didn't check that, okay.
I didn't check, no.
Okay, no one else has a question or comment? And so what I'm going to do, you're finished, correct?
Yeah.
Okay, just sit for a moment. I'm going to just see if there's anyone from the public that would like to speak. Sir, are you here for the, yeah, come on up. Just, if you would, your name and address for us, please.
Yes, Hubert Hawley, 28 Avon Street in Malden, and that's Edgewood Precinct 2. Someone in my family has owned a home in that particular precinct for at least 100 years. For myself, I grew up on West Street. I'm now on Avon Street near Pearl. Although I'm several blocks from Whitman Street, I'm quite familiar with the property. And I don't think it, looking at the sign recently, I don't think it's detrimental to the area. It doesn't change the character of the area that I've known for a long time. If it was a new building, new sign, there might have been more opposition, I think. But myself and my neighbors, who I believe have a lot of pride in the neighborhood, and it's come a long way since I was a kid in there, I don't think it's a bad thing at all, the way it looks right now.
Yeah, Hollywood even used it a year or two ago, right?
I'm sorry?
Hollywood even used that neighborhood a couple years ago for a movie.
Holly for what?
Hollywood, they filmed the movie down that street there, the shooting
right,
scene.
Right down on Highland
Yeah.
Ave.
Yeah.
Yeah.
You mentioned family 100 years, on which, you talking about a property right in the vicinity? Because I know West and Avon are not direct abutters.
Well,
When you said
when I
100
was
years,
on-
were you saying in that area?
No.
Okay.
Okay. Several blocks down on Pearl Street, but as close to Pearl Street as that business is. My property is as close to Pearl, distance-wise, although I'm several blocks south of Whitman Street.
Near the old Brandanos.
I'm sorry?
Near Brandanos. Brandanos.
Oh. Well, I was here. I was property owner when that issue came up, and we were quite happy with that result.
Yeah, that's dental
Even
research they
though
do.
the food was good, it was not a place for a restaurant and bar.
All right, anything else?
Thank
Great,
you.
thank you. So I believe you were in support of this being granted, I think, correct?
Yes.
Thank you. Okay. Anyone else have a question or comment? And John, go ahead.
Oh, just another comment, I guess. This sign, nothing against Everett, but, the sign came from Everett. I have no idea what the building looked like, what size the building was, if it was down near the Encore, I know that it's, in a business area probably. This is a residential area, and they do have a way to identify the building, and, and if the owner of the building wants something with allowing them to identify the business and have their numbers on it, I think, that can be done by a sign company with a smaller sign. This is just a make-do kind of thing.
Can I see those pictures again?
It's something that,
The numbers that Mr. Sullivan referenced are on a different sign, I believe, not on the main, what I'm going to call the main sign here.
no, but
Yeah.
I don't know, but you mean, if a sign company can do, telephone numbers and all that stuff on a smaller sign,
Yeah.
for them that would match what was there, in which, they have the right to put up, but to extend this sign, which, like I say, is probably more than actually.
Yeah, do you know how much bigger it is than what was there before? Okay. All right.
If you just look at the door opening from the original, where the
Oh, yeah,
original
that's a
sign
good point.
is there. When it was Middlesex.
Collision.
It is within the frame of the door.
Yes, right, you're right.
And this is.
Yeah. Did I hear you say that sign physically came from Everett? That's a new sign, correct?
No, that came from
It did come from your Everett store?
yeah, and we
Okay,
were-
that's what you were suggesting. I didn't
That's what
realize.
he said,
I
yeah.
thought you built it new.
Yeah, no, we were in a mixed-use.
Yep.
Residential neighborhood and industrial neighborhood,
Sure.
right across from where they're building.
So you
the
didn't
casino.
expend any money and go have a new sign
That
made?
was that was the thing, was to save money with
Now
the
you
move
maybe
and
will.
everything. We reused the sign.
All right, great.
So
Oh, I'm sorry.
I went by this weekend, I thought that the sign looked good in the neighborhood. It is in Residence A, but it's mere blocks from Highland Ave, which is a more commercial area. I thought it fit with the neighborhood. It was a tasteful, good-looking sign. I thought that it looked natural in the context of that block.
We've done a lot of painting and stuff on the building.
Yeah, it looked nice,
and
looks nice.
Trying to make it look nice.
And it's not illuminated, correct?
No. No?
All right, anything else? Thank you.
Thank you.
All right, could I entertain a motion?
I'd move that the petition be denied.
Okay, would there be a second?
I'll second that.
All right, all those in favor? Aye, okay, so unfortunately, it was denied. I don't know if if you couldn't come back, I don't think, but if you had the same sign, size-wise, it might have, I think it might have had more likelihood of having been passed. I can't be certain of that, but it's just my opinion. All right, thank you. Anything else to come before the board? We have a meeting next month, do we? That would be oh, we have the tabled one for Highland Ave that Mr. Sullivan and I will visit. And you were expecting the attorney, Mr. McDonald, to provide some, what would it be, case law about?
If you want, I mean, it's his choice, if he wants to bring it, it just would be
Okay.
helpful for me, because I'm just a little torn about.
Okay, and you were torn that, you were questioning whether we could revisit it in this manner?
My concern is that it seems to me that the prior people, you know, they were given the variance, they kind of said, no, we're not gonna do it, you know, we're gonna completely ignore it, and now we're kind of coming back and revisiting it. There has to be some, that has to have happened before, and I'm just curious how it's been dealt with. You know,
Okay.
You know, if there's any sort of cases on that, or
Okay.
any authority.
All right, so, motion to adjourn.
So moved.
So moved? Okay, see you all next month.
Not me.
Thank you. No, are you in Florida? Okay.